What up, family? This is your boy Ivan Hall, the Credit King. Have you ever wondered what debts can't be discharged in bankruptcy? The following list gives you a quick rundown of debt you can't discharge in bankruptcy. Child support or alimony. Student loans unless the court agrees it will cause undue hardship to the debtor or his family. Taxes unless they are over 3 years old or more. Fraud. You lied on an application or some type of fraud was involved. Debts not listed may not be dischargeable if the debtor was fully aware of them and did not list or notify the creditor. Debts incurred to pay federal taxes. Credit cards used within 60 days for anything other than absolute necessities. Debts that were included in a previous bankruptcy that was dismissed within the preceding 180 days. Unexplained or disappearance of assets. Abuse of the bankruptcy process. Other creditors can try to have your bankruptcy dismissed if they find you showed preference to other creditors over them. Debts that are non-dischargeable generally fall into the following categories. Individual income taxes that are assessed within 3 years of the filing but remain unpaid. Debts that have been incurred by the use of false financial statements or by the use of other false pretenses. Unscheduled debts, in other words, debts that the debtor failed to schedule as required at the start of the bankruptcy case. Debts that arise from fraud or embezzlement, or from the misuse of funds when the debtor was acting as a fiduciary. For example, embezzling money from a relative's trust fund over which the debtor had control. Alimony, maintenance and child support. Any debt incurred from willful or malicious injury is generally non-dischargeable. Fines and penalties are non-dischargeable. Most educational loans cannot be discharged, although a hardship exception allows a debtor to avoid certain educational loans. Debts for luxury goods or services over $1,000 incurred within 60 days of the court's order of relief. Debts for cash advances in excess of $1,000 on credit cards incurred within 60 days of the court's order of relief. Debts arising from a judgment incurred from drunk driving. The 3 R's are actions you take in regards to a particular debt. Redeem, you pay the balance in one lump sum to the creditor. Rescind, you give back the property to the creditor. Reaffirm, make a new court-approved contract and repay. You can make a voluntary repayment plan with a creditor without the court's approval as long as it is not considered a preference. This may be beneficial to you because, unlike the reaffirmation, you can stop paying at any time and the creditor cannot attempt to collect. That is because it was solely voluntary and not a court-approved reaffirmation. If you plan on reaffirming, make sure you want this. Once the court approves it, it is considered a new debt. Creditors risk a lot by doing reaffirmation not approved by the courts. Sears was sued for $400 million over a $300 debt. All because they did not get court-approved reaffirmation and then proceeded to collect when the debtor stopped paying. Although most debts can be discharged in bankruptcy, certain debts are not dischargeable by individuals in a Chapter 7 liquidation. Other debts that are normally dischargeable may be denied a discharge, generally because of the actions of the debtor. Many banks and credit unions have enacted the CCC, cross-collateral clause. If you are subject to one, it must be in your contract terms and disclosures and be obviously displayed. A CCC is a clause that allows the creditor to secure your unsecured debts with other secured loans that the creditor may hold for you. A common use of this is if you have an auto loan and a line of credit or Visa. While it does not stand up well against visas because of Regulation Z, it does stand up against most unsecured debts. That means if you file bankruptcy and think you are going to reaffirm the car, the creditor can also demand that you reaffirm the visa, or they can literally hold your title hostage. This method, however, cannot be used with mortgages, or the creditor will lose all future rights to offset the mortgage should they attempt to offset payments by enforcing the CC clause. What if I filed bankruptcy and it was dismissed? A dismissed bankruptcy means that you will be once again liable for your debts. There is a big difference between your debts being discharged and a bankruptcy dismissal. If bankruptcy is dismissed, all bets are off. You'll have to figure out at that point how you're going to pay your creditors or if you will refile your bankruptcy. Dismissal can happen for a number of reasons, but typically it's because the court found problems with the filing or the debtor violated the terms. Once the bankruptcy is dismissed, that information will be reported to the credit bureaus as well. Again, be very careful if you should ever file for bankruptcy. Get yourself some good counsel and go get that money.